With the consent of the opposite party, this matter stands adjourned 4 weeks, list accordingly.
My lord, there is an interim operating in this matter.
Interim order passed earlier to continue, never signable.
Deeply operating.
May I pray for listing of a matter for motion tomorrow day after?
But I have mentioned for day after tomorrow. Mention.
Motion,
Motion, madam.
admission, no listing.
No,
will be
no,
allowed.
motion.
Motion, madam.
Motion allowed.
May I please receive? So I will to mention item number 20. Let's do consent of the other side. Let's do kindly matter me come after vacation.
You are for whom?
Petitioner, let's do.
On the prayer of learned counsel for the petitioner made with the consent of the other side. This matter stands adjourned for 4 weeks, list accordingly.
I'm going to respond in this case.
Mr. Your name, please?
PM Talukdar Lodge.
Mr. PM Talukdar.
Private respondent 4.
Is present on behalf of private respondent number 4.
May please your lordship, I beg to mention item number 19 with the consent of the other side. The matter may be listing after vacation.
You are for petitioner.
And no, I am the respondent.
Respond number,
5 and 6.
you have informed the other side.
Yes.
The learned counsel for the respond numbers 5 and 6, Mr.
A.K. Hannan.
A.K.
Hannan.
Anand. 6, adjournment in this case with a request to post the matter again after the Puja vacation. Since the prayer is made with the consent of the petitioner's counsel, same stands allowed, list accordingly. Yes.
Deeply obliged, ma'am.
Daily list for motion item 1.
May I please your lordship? As per my lord's direction, my lord, we are required to file an affidavit. But today we are filing it. My lord, with all humbleness, I am praying, my lord, let this matter come immediately after vacation. My lord, let it be fixed on my lord 7th of November. It's a hearing day. Because we have urgency. In the meantime, my lord, they may choose to file any reply. Because we will be filing an affidavit comprehensively on the whole issue. It is in the process, my lord.
All right, Mr.
J. Abbas.
J. Abbas, learned counsel for the petitioner is present. Petitioners is present. Mr. R. Borpujari, learned standing counsel, Revenue Department, Assam, appearing for the respond numbers.
My lord, respondent 1.
Respond number 1 submits that in terms of the order dated 6/10/2023 passed by this court, the department is in the process of filing affidavit in the matter during the course of the day.
Yes, my lord.
As such, expressing urgency in the matter, Mr. Borpujari prays for posting this matter again on 7th of November 2023. Posting this matter again after reopening of the Puja vacation, that is on 7th of November 2023, so as to enable the parties to exchange pleadings. Full stop. The prayer is not opposed by Mr. Abbas, learned counsel for the petitioner. Mr. J. Hendik, learned G. Assam is present on behalf of the official respondents. Taking note of the request made at the bar, this writ petition is directed to be listed again on 7th of November 2023 as a fixed item. Parties to exchange pleadings in the meantime. Interim order passed earlier to continue till then.
Yes, yes.
Obliged.
I'm so obliged, my lord.
Obliged.
Item 2.
My pleasure, madam. By filing this petition matter, we have come for a direction to be issued by this honorable court to the deputy commissioner, respondent 4, because we have submitted a representation, my lord, seeking, my lord, approval of the constitution of the committee under the Jalwa mission, my lord, Jal Jeevan mission. And deputy commissioner has kept the matter pending. So, my lord, at this stage, my lord, we are not going to trouble your lordship. Simply a direction be issued to the deputy commissioner to dispose of the representation and take a decision independently.
Which representation?
At page 100 and at 7, 155. Matter
155.
155. We are the president and secretary member of various committees which were constituted under this scheme in respect of 13 numbers of my lord. The scheme is water use, my lord, supply, water supply schemes.
Yes, what do you have to say, Mr. Henry?
Okay, मला that
Hmm?
representative may kindly be मला directed to dispose of. Land of plan is coming
Malad.
from an IPR for.
I appear for the PHE department, my lords.
Yes.
These bodies, my lords, they've been constituted without there being an approval or an order from the PHE department for the constitution. And normally the procedure that is adopted, the PHE department will earmark certain areas which lack the requisite water resources, my lord.
What
Then
is
the
means the WUC?
WEC, my lord. Now, water user committees, my lords. So after that process is done, my lords, the government, the village level, at the village level, people will get together and formulate a certain plan or for allotment of the land so that a water supply system can be installed, my lord. Now here, my lord, there is no such order from the PHE. This has been done on their own accord. There is no direction, there is nothing.
So Mr. Pukaso, then we'll have to issue notice.
My lord,
The
DC
PHE department has objection.
well, they are continuing them, and our whole continuing is that initially there was some initiative taken by the government.
Mr. Pukaso, you have a submission, he has a contra submission. The court has to arrive at an opinion, is it not? Take down heard Mr. A.K. Pukaso and a counsel appearing for the writ petitioner. Peruse the averments made in the writ petition. The petitioners claim to be the selected presidents and general secretaries of the various water users committees of the PWSS. What is PWSS?
Pipe water supply schemes.
supplies.
Pipe Water Supply Scheme bracket PS PWSS bracket close under Gotabari 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 Popatia KHOPATIA Gao Panchayat full stop. Agree by non-consideration of their prayer for granting approval of the WUCs so constituted by the District Commissioner cum Chairman of the District Water Supply Mission bracket DWSM bracket close of South Salmara Mankachar, Hat Singhi Mari. That is the respondent number. Respondent number 4 herein. The instant writ petition has been filed seeking a writ of mandamus directing the authorities to approve the aforesaid bodies, full stop. Mr. B. Chaudhary, learned standing counsel, PhD department. Assam has opposed the prayer by contending that these WUCs have been constituted in an arbitrary manner without obtaining the approval of the PHE department, and therefore they do not have any legitimacy in the eye of law. Under the circumstances, the approval as prayed for cannot be granted. Mr. Chaudhary also prays for 4 weeks' time to file affidavit, bringing the stand of the department on record. In view of the above, issue notice of motion returnable in 4 weeks, since Mr. B. Chaudhary, learned SC PHE Department, Assam, has appeared and accepted notice for respond numbers
1, 2, 3, and 6, my lords.
1, 2, 3, and 6. And Mr. J. Henrik, learned additional senior government advocate, Assam, appearing for respond number 4. Service of notice upon the said respondents is deemed to be. Who is appearing for 5?
My lords, I have never,
What is this additional district commissioner PHE?
ADC, PHE, my lord, there is no post as such, my lord, I believe.
Because direction was issued by ADC to hold an inquiry.
Where is?
All right, service of notice on the said respondents is deemed to be complete in this case.
Seven.
Extra copies of the writ petition be furnished to the learned departmental council, requisite numbers, within 3 days from today. Petitioner to take steps for service of notice upon the remaining respondents by registered post with AD within 7 days from today. The learned departmental council to obtain instruction facilitating disposal of the writ petition at the stage of admission hearing.
Obliged.
Item 3.
May I please, your lordship?
Yeah, yes.
My lord, my lord, matter pertains to, my lord, non-referral of my representation, my lord, that is as regarding, my lord, some anomalies in, my lord, disbursing compensation to me, to the, my lord, competent court as part of mandate of the act, my lord. My lord, my land has been, my lord, acquired by the, my lord, Deputy Commissioner of, my lord, Kamrup, under the section 3 of the Land Acquisition Act, my lord. And there is some, my lord, anomalies regarding that.
Will issue notice at this.
My
Heard Mr. B.K. Das, Land Council appearing for the writ petitioner. The petitioner claims to be the owner of a plot of land measuring 1 bigha 4 kathas, which was acquired by the respondent number 4. For the purpose of, why was it acquired?
My lord, it is for, my lord, for setting up dispatch terminal cum compressor station for Northeast gas grid pipeline. Or it, my lord, on page 31, my lord, annex 4.
For
Page 31, my lord, on the first para, bottom. Above the city.
for setting up within quotes dispatch DISPATH dispatch terminal cum compressor station for Northeast gas grid pipeline. Page 31 of power. Unquote, dispatch of quote over pipeline unquote. According to the petitioner, due to some alleged anomaly on the as regards the title of the petitioner pertaining to the land, the amount of compensation has not been paid to him till today. Even the request made by the petitioner for referring the matter to the district court has not been acted upon by the respondent number 4. Hence this writ petition. The learned departmental counsel appearing in this case have prayed for some time to obtain instruction. Issue notice of motion returnable on 10th of November 2023. Mr.
I'm for respondent number 1.
Mr. S.S. Roy, learned CGC has appeared and accepted notice for respondent number 1.
And for 427.
And Mr. J. Hendik, learned additional government, senior government advocate Assam has appeared for respondent numbers 4 to 7. You are for Ms. G. Hazarika, learned SC Revenue Department has accepted notice for respondent number 3. As such, service of notice upon respondent numbers 1 and 3 to 7 is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned department council within a week from today, so as to enable them to obtain instruction. Petitioner takes steps for service of notice upon the remaining respondents by registered post with ODP.
My lord, can it be possible to give an observation, my lord, till the next returnable date, not to disburse the amount of compensation in respect of the, my lord, disputed land of 2 kathas, because they are contemplating to release the amount, my lord,
As per the, my lord, that
to some other person, man.
section 12, my lord, that my lord, they have the right to, my lord, submit the application before the, my lord, deputy commissioner. That will be the referred to the, my lord, district judge. How can, my lord,
Right,
this one-
heard on the prayer of interim relief. By way of an ad interim measure, it is provided that the respondent shall not disburse the amount of compensation without proper verification of title over the land till the returnable date.
Item 4.
10, 11.
May please your lordship, the petitioners will submitted an application for convergence land from allotted land into periodic pata in the Mission Bosundara Hotel Lordship, but the same has been rejected with a reason to the no submitted the allotted certificate, allotted land certificate. Lordship. The petitioners were, all documents were submitted in the online system. My lordship, prayer, lordship, my
We'll issue notice at this stage
lordship, direction to the disclosure of my representation.
without issuing notice.
Disclosure of lordship, page 58.
At
lordship.
Mr. N. Amel, counsel for the petitioner. The petitioners are aggrieved by rejection of their prayer for allotment of land under the within course, Mission Basundara, unquote, portal on the ground that they have failed to submit proper documents. Full stop. Mr. Ahmed submits that his clients have submitted all the requisite documents and therefore the order of rejection is arbitrary and illegal. Mrs. Sharma and G. Assam appearing for this day.
2 and 3, my lord.
Some time to obtain instruction in the matter. NOM 6 weeks since Ms. Hazarika Lanet, Standing Council Revenue Department Assam has appeared on G. Hazarika has appeared and accepted notice for response number 1 and Ms. S. Sharma and G. Assam for response numbers 2 and 3. Service of notice is deemed to be complete in this case. Extra copy of the rate petition, requisition numbers be furnished to the learned departmental council so as to enable them to obtain instruction facilitating disposal of the rate petition at the stage of admission.
Item 5.
May I please your lordship?
File has come. 7.
Lordship, this is a case where the petitioner's father-in-law has donated a plot of land. The petitioner's late husband has donated the plot of land in favor of the in school, which has to be set up in the name of the late father-in-law of the petitioner. So what happened? The school got amalgamated to some another school. Now the government is proposing to set up an employment exchange in that particular building, but there is a condition in the gift deed. All the gift deeds that it should be used for school purpose and only in the name of his late father-in-law. Otherwise, the gift deed will not be selectively returned back to the the legal successors. And there is
It's a conditional gift.
a conditional gift, yes,
Is it permissible under the law?
under section 31,
Under section,
126, 131, transfer of property.
let us see.
EPA 31. Transfer of property. But you may see annexer 1 at page 23. The gift deed is there.
You're referring to section 126.
126, 31.
Yes. Who's appearing? You are appearing for?
1, 5, 6 and 7.
So the land was given for setting up school in the name of petitioner's father. Then you want to now do something else?
The order which has been impugned in this repetition.
Where is it?
Page
Let us see.
52.
Hmm. Yes.
Page 52.
Hmm.
That has been passed by the additional deputy commissioner.
Hmm.
They are not challenging the order of amalgamation of the school with the order which was passed by us.
Hmm.
The
You have amalgamated the school
with one the
Deshobandhu
Deshobandhu Vidyalaya High School.
that's all right.
That amalgamation order is not put to challenge.
Yeah, but then now you want to set up an employment exchange in that.
It is the deputy commissioner, my lord, who
All right. But Mr. B. Chaudhary, our counsel appearing for the writ petitioner, the husband of the petitioner had donated a plot of land in the year 1966 and 1982. for the purpose of establishing a AMI Girls School at Hojai Town in the name of his deceased father. Full stop. In the year 2022, the school was amalgamated with Deshabandhu Vidyapit
Girls High School.
Girls High School. In the name of his father, namely Kali Krishna Balika Vidyalaya.
Adarsa Balika.
No, what was the name of the father?
Father's name was Kali Krishna, father-in-law's name was Kali Krishna Dev.
That is in the name of his deceased father, that is late Kali Krishna Dev. Accordingly, Kali Krishna Balika Vidyalaya was set up subsequently, in the year 2022. His said school was amalgamated with Deshabandhu Vidyapit Girls High School, and the name of the school got changed. First of all, by issuing the impugn order dated 12/6/2023, a decision has now been taken to temporarily set up employment exchange office of Hojai in the above mentioned school. Aggrieved thereby, the instant writ petition has been filed, inter alia contending that the impugn order is hit by section 126 of the Transfer of Property Act. First of Mr. B. Kaushik, Learned Standing Council, Higher Education. Elementary Education Department, Assam submits that the impugn order has been passed by the district administration authorities, but since the petitioner has not challenged the amalgamation of the school, she has forfeited her right to assail the impugn order as well. Ms. S. Sharma, Learned G. Assam, prays for some time to obtain instruction in the matter. Issue notice in motion returnable on 17th of November 2023. Since who is appearing and accepting? Since Ms. Sharma has appeared and accepted notice.
1, 5, 6, and 7.
Ms. Sharma, Learned G. Assam has appeared and accepted notice for respondent numbers 1, 5, 6, and 7, and Mr. Kaushik,
2 and 4, my lord.
Learned SC Education Department for respondent numbers 2 and 4. As well as Ms. G. Hazarika, Learned SC Revenue for respondent number 3. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the Learned Department Council so as to enable them to obtain instruction. You have some interim relief?
Yes,
What is the interim relief?
this impugn order 15/6/2023 has to be.
6 June month.
June.
What has happened?
They were for the establishment of the employment exchange.
No, but has any steps been taken?
We have submitted the representation. That represent on the basis of that representation, the ADC has written put up the matter.
Actually, you write hard on the prayer of interim relief, having regard to the facts and circumstances of the case. It is hereby provided that operation of the impugn order dated 12/6/2023, bracket annexure numerical 5, bracket close, shall remain state in the returnable date. It is however made clear that pendency of the writ petition shall not be a bar for the authorities to consider the representation submitted by the petitioner and redress her grievance in accordance with law if so advised. Let this matter be listed again by reflecting the name of Learned SC Revenue Department Assam in the cause list.
Supplement is for motion item 28.
Where is the impugn order?
It is annexure 1, my lord,
Page number?
page 22, my lord. What has?
Who is appearing? How come the recovery officer issues direction to cancel mutation?
And that too against a person who was never a party either to the original proceeding or to the recovery proceedings. And the most interesting part, my lord, is that I have purchased the property before the creation of mortgage. How my mutation will be cancelled and why I should be disturbed from running my brick till. At least an opportunity ought to have been given to me, but they are not ready to even listen to me.
Where is the operative part of the order?
There are two orders, my lord. Annexure 1, operative part is, my lord, page 23, last but one paragraph.
Hmm.
NITFI is also directed to serve one copy of today's order upon the Deputy Commissioner of North Lakhimpur District to issue necessary direction to the concerned circle officer to cancel the mutation as recorded in the name of Ayub Khan, and Ani Sultana and Ashik Khan, and noted the mortgage in favor of NITFI as GD has sold out the property after creating valid mortgage with NITFI. This is one order, my lord, and on next date, that is on 10th of October, it was again fixed, which is at Annexure 3, my lord. Annexure 4, my lord, page 27. Same order has been reiterated, my lord. As page 28, your lordship will find the relevant portion. NITFI is directed, last but two paragraph, my lord. Directed to serve one copy of today's order upon the Deputy Commissioner, North Lakhimpur District to issue necessary direction to the concerned office, circle officer to cancel the
So
mutation.
they are the petitioners, A, B, C, three petitioners. They are the writ petitioners.
We are the writ petitioners, my lord.
And what has
and we-
happened? This order has been implemented.
No, till now it has not been implemented, but NITFI is approaching the circle office. We are in extreme anxiety, my lord.
Yes, Mr. Pandit, are you appearing in this case?
Lordship, I appear on behalf of respondent number 3, 4, and 5, Lordship, Deputy Commissioner. Or is the order was, or the direction was given by the, my lord, that
And who
Deputy
is respondent number 6?
He is the person from whom I have purchased, Mofidul. He has created the mortgage, but only after the property was sold to me,
And which is the bank involved here?
NITFI, my lord.
NITFI.
Netflix is made a party, Lordship, respondent number 2.
Respondent
Their
number
name
2.
not been reflected in the list, Lordship.
No, they haven't been made party.
Made party, their
NITFI has
name,
a standing council.
I think so, earlier, my lord,
No.
Netflix, my lord.
No, my lord, they don't have any standing council.
All right. Take down.
Otherwise, registry would not have accepted it.
Heard Mr. S.K. Singh, Leonard Senior Counsel, assisted by Mr. Huh? A.
Dhanuka.
A. Dhanuka, Leonard Counsel, appearing for the writ petitioners. Peruse the amendments made in the writ petition. The instant writ petition has been filed assailing the order dated 10/10/2023,
And 8/9
as well as
8, 9, and 10.
8/9/2023 and except to one.
Instant writ petition is directed against two orders passed by the learned recovery officer, Debt Recovery Tribunal, Guwahati, dated 8/9/2023 and 10/10/2023, arising out of RC public 3035 public, no, arising in RC stroke 3035 public 2018, arising out of way number 395 public 2017, whereby a direction has been issued to the District Commissioner of North Lakhimpur District to initiate necessary action for cancellation of mutation of the names of the petitioners in respect of the land in question on the ground that the plot of land has been alienated after creating a valid mortgage with the net fee. Mr. Singh submits that his clients had purchased the plot of land from the respondent number 6 prior to creation of the mortgage. Not only that, the petitioners are neither parties in the recovery proceeding, nor have they been heard before issuing the impugned order. Notwithstanding the same, by issuing the impugned orders, the learned recovery officer is seeking to strike off the name of the petitioners from the land in question, which is the property purchased by the petitioners bona fide for valuable consideration. First of. Mr. J. Handy, Lanet, Additional Senior Government Advocate Assam, as well as Ms. N. Bordelon, Lanet SC Revenue, have waited for some time to obtain instruction in the matter. Issue notice of motion returnable on 8th of November, 8/11/2023. Since Ms. Bordoloi has appeared and accepted notice for respond number 1 and Mr. Henry for respond numbers
3, 4, and 5 Lord.
3, 4, and 5. Service of notice is deemed to be complete on the said respondent. Extra copies of the writ petition be furnished to the learned departmental council within 3 days from today. Full stop. Petitioners to also take steps for service of notice upon respond numbers 2 and 6 within 3 days from today by registered post with AD. Hard on the prayer of interim relief, considering the facts and circumstances of the case, it is hereby provided that operation of the impugned orders dated so and so and so and so. It is annexure order dated 8/9/2023, annexure 1 and 10/10/2023,
And except for.
annexure 4 numerical bracket shall remain stayed till the returnable date.
Highly explained.
Order impeachment of party item 6.
IA has been filed to implement the chief engineer and the executive engineer, page 35, my lord, paragraph 2 and 3, my lord. Due to oversight, my lord, the chief engineer of a different division was included, my lord. So the chief engineer, paragraph 2 and 3 I have stated, my lord.
You want to implement Pavan Tarang and Prashant Lanthas?
Yes,
right?
yes, ma'am.
Earlier, they were not implemented by oversight.
Yes, ma'am.
But
Already
they
we have-
demanded compliance of the
Yes,
order.
yes, that is already done, ma'am. Only wrong person was here.
Mr. B. Borwa, learned counsel for the applicant, submits that this IA has been filed for improvement of the respond numbers 5 and 6, that is Sri Pavan Terang, Chief Engineer, Public Works Department, bracket EAP, bracket close, Patasi Lambari, Guwahati, and Sri Prasanta Lanthas, in charge executive engineer, Public Works Road Department, Haflong, Dimahasa District, as parties to the contempt proceeding, since they were earlier not implemented by oversight, and in their place, the wrong officials were made a party in the contempt case, contending that the said respondents are responsible for implementation of the court's order, and despite demanding compliance of the order, they have failed to take any step in the matter. Mr. Borwa submits that this is a fit case where the aforesaid two respondents ought to be implemented as respond numbers 5 and 6 in the connected contempt case. Ms. J. Gogoi, learned counsel, appearing for the
6.
respondent.
Dimahasa.
Dimahasa Autonomous Council is present and does not have any objection to the prayer result. In view of the above, the respond numbers 5 and 6 be implemented as respond numbers 5 and 6 in the connected contempt case. Petitioner to file amended cost title within a week from today. Let the matter be listed thereafter for orders. IA stands disposed of.
Obliged, ma'am.
For admission, item 7.
My lord, the matter may be in time.
This matter actually is demerit charges, my lord.
My lord, because my senior is on the way, after attending parents teacher meeting of his daughter. So my lord, matter may be for the
Actually,
time being.
I have nothing to add, my
There will be bigger damage in his life.
matter was concluded.
time.
Last occasion, Lordship directed him to produce as to how,
So, yes,
how we
by,
calculate.
by what time is your senior likely to reach court?
After.
How long should
11:30
we wait? That's what we are asking.
After 11:30.
11:30.
Precise time.
11,
Precise timing.
11:15, my lord.
11:15? Okay, we'll wait.
15 minutes, my lord. Obviously.
Massive damage if he fails to attend. In his own way. Yes, yes, we'll wait.
I can wait.
May it please your lordship, in this matter, affidavits are still to be filed by the respondent council. my lord.
Lordship, may,
May what?
post after lordship a vacation, lordship.
Why? Why after vacation?
Lordship, I'll file my affidavit, lordship.
Oh, you have not been able to file it since 2020.
Lordship, in fact, lordship, case is that lordship, the assistant executive engineer has issued a notice, lordship, to vacate the particular land, portion of the land, lordship.
So there is a stay order.
There is
There
a
is stay order, lordship.
We'll have it after winter vacation then.
Lords, no problem.
You want to delay it, then why should he be troubled?
In
Tell
fact,
him-
lordship, my,
ADAS, my lord.
Huh?
ADAS.
Mr. Adas, Learned Counsel is present on behalf of the petitioner and submits that despite seeking adjournment, the respondents are yet to file affidavit. Mr. N. Upadhyay, Learned SC Irrigation Department.
I am for 1 and 2, lord.
Appearing for the respondent numbers 1 and 2, prays for further 6 weeks time to file affidavit. Similar is the prayer made by Mr. Miss N. Bora, Learned Counsel, appearing for the respondent numbers 3 and 4. No, respondent number 5. Who is for 3 and 4? Mr. J. Hendy, Learned Additional G. Assam for respondent numbers 3 and 4, and Miss N. Bora, Learned SC, PNRD Department Assam for respondent number 5. In view of the above, this matter stands adjourned for 6 weeks so as to enable the Learned Departmental Council to obtain instruction and file affidavit. Interim order passed earlier to continue
Obliged.
until further notice.
Item 9.
May it please your lordship.
Yes.
My lord, matter pertains to my lord, settlement of land, my lord. Here, my lord, petitioner's father, my lord, late Mohanlal Sharma, my lord, that possessed a plot of land, my lord, measuring 1/5 lessa, my lord, since 1970, my lord. And from 1971 to 1996, my lord, he had been regularly paying the revenue tax, my lord. However, my lord, in the year 2000, my lord, some settlement proceeding was initiated, my lord, and some steps were also taken, my lord. In the year 2005, 2009, my lord, GMT had also, my lord, allowed, my lord, the settlement in favor of the petitioner, my lord. Now, my lord, although, my lord, the proceedings has been initiated, my lord, but they did not conclude the proceeding for settlement, my lord. Now they have come up with a affidavit saying that there some other family members are possessing land, so I am not eligible, my lord, for settlement. My lord, that land has been possessed.
Other family member means who?
My lord, a son of the deceased father, my lord, my brother, my lord, petitioner's brother, my lord. He's residing separately, my lord.
Sorry?
Separately, my lord. He is separated, my lord. Now, my lord, the land was originally possessed by the petitioner's father, my lord, Mohanlal Sharma, my lord. And
So is there any such clause in any proceeding, any notification anywhere that if a sibling owns land, then he will not be entitled to? What is the basis of this stand?
Basis, lordship, my lord, in our affidavit, we have stated in paragraph 5 and 6, lordship. My lord, in the 6th, my lord, the petitioner is not a landless person, lordship. As per
So
the-
where does he have land?
The petitioner having that is it is not mentioned, my lord, in the.
Then how can this be accepted? If he is not a landless person, then you have to say. That's 6.
He was applied.
So where is the record in support of this statement in para 6? This is sworn from record. Please produce the record.
Nothing, Lordship, my lord,
Sorry. Para 6 of the affidavit.
Lordship, my lord, nothing, no records has been, my lord.
No, but it is mentioned that it is shown from records.
Lordship, my lord, let me take instruction, my lord. I will file an
Produce
additional
the record,
affidavit.
otherwise,
Lordship,
we'll proceed in contempt against the deponent. Mr. S. Hawk, learned counsel for the writ petitioner submits that the application for allotment of land made by the petitioner has been denied on an arbitrary and illegal ground by stating that the petitioner is not a landless person, which is factually incorrect. First of all, Mr. Hawk submits that his client does not own any land. And therefore, the averment made in para 6 of the writ petition, para 6 of the affidavit in opposition filed by the respondent number 2 is wholly incorrect. Mr. Hendick also could not substantiate the statements made in para 6 of the counter affidavit. I find that the aforesaid paragraph has been shown from knowledge derived from records. As such, the learned government advocate Assam is directed to produce the records on the basis of which averments have been made in para 6 of the counter affidavit. Records be produced on the next date fixed. Registered to list this case again on 20th of November 2023 as a fixed item.
Publish.
Item 11.
Yes.
May I please, your lordship. This was an NGO lordship, a halfway home lordship. They run an NGO by signing an agreement with Social Welfare Department lordship. But they did not release to financial year amount lordship. Earlier they paid and 2022-23 also they paid lordship. But between these two financial year did not release lordship. That is why this petition lordship.
Who is supposed to release the fund?
Social Welfare Department.
Social Welfare Department is still there. Is that department still there?
And environment now.
Social justice and
Well, there are two parts, Lordship. One is social justice and empowerment, Assam, Lordship. My lord, they are the main, my lord, their response.
so who is appearing for that department?
Lordship,
What is your stand?
my lord, let me take instruction, my lord, that whether in some other case also, my lord, last week, my lord, I was appeared in the court number 17 also. That we have already been, proposal was submitted to the, my lord, the finance department. My lord, due to non-sanctioning of the, my lord, the approval of the, from the finance department, we could not be paid, Lordship. So let me take
How
instruction.
much time do you want?
Lordship, release them at after vacation.
We'll do it, but on the next date, if by that time, if the affidavit is not filed, then the director will remain personally present.
Lordship, definitely.
Heard, Mr.
J.
J.
You
Ahmed, and a counsel appearing for the writ petitioner. The grievance of the petitioner is that despite the agreement signed by the petitioner NGO with the Director of Social Welfare Department Assam, bracket presently, the Department of social justice and empowerment, bracket close. No fund for running the halfway homes by the petitioner NGO has been released till today. Full stop. This writ petition was filed with the above prayer on 2/4/2022, but till today, no affidavit has been filed. Mr. J. Hendrik Leonard, additional senior government advocate Assam appearing for the departmental authorities also submits that he does not have any instruction in the matter. Be that as it may, on the request of Mr. Hendrik, this matter is directed to be listed again on 2023 as a fixed item, so as to enable the respondents to file affidavit. It is made clear that if the affidavit on behalf of the Social Justice and
And-
Empowerment Department is not filed on or before 16th of November 2023 by serving advance copy upon the petitioner's counsel, then for any reason, then the director of the department shall remain personally present on the next date fixed to answer the queries of the court.
Lordship, fix it on.
20th of November.
Obligation.
Item 12.
May I please, your lordship? In this case, your lordship, the husband of the petitioner had died due to murder, your lordship. And thereafter, the petitioner submitted a representation by seeking the relief under, in terms of the notification dated 18/10/2012, that is Assam Victim Compensation Scheme, your lordship. On last occasion, honorable court issued notice, and thereafter, your lordship, the respondent number 3 filed an evidence and additional affidavit in opposition, your lordship. In this evidence in affidavit, your lordship, they are made the averment, the petitioner are entitled under the section of CRPC, that is 357 of A, your lordship. Due to non-ability of fund, they are not sanctioning the amount in favor of the petitioner.
Is the finance department a party here?
No, lordship, I think.
Then we have to inflate
Let me
because
say it.
they said that there is no fund. Otherwise,
Yes,
your clients claim, yes, I heard Mr. S.R. Akan, counsel appearing for the lead petitioner, also heard Mr. J. Henrik Leonard, government advocate Assam appearing for the official respondents. The instant lead petition has been filed seeking victim compensation on account of
they don't-
murder of the husband of the petitioner. Full stop. The claim of the petitioner has not been denied. Today, when the matter is called up, Mr. Hendrik has produced a copy of the communication dated 16/10/2023 issued by the Office of District Legal Service Authority, Jorhat, a perusal of which goes to show that an amount of rupees 5 lakhs as victim compensation has already been sanctioned for being paid to the petitioner. However, due to paucity of fund, the amount could not be disbursed till today. First of, in the said letter, it has also been mentioned that since the year 2019, no funds have been received under the within course Assam Victim Compensation Scheme, 2012. It is correct that unless funds are received under the scheme, no payment of victim compensation has been made. It can be made even to the genuine and deserving victims. Full stop. However, the reason as to why funds have not been released since 2019, as has been alleged, is not yet known. As such, the Commissioner and Finance, Commissioner and Secretary to the Government of Assam Finance Department is hereby implemented as respond number 6 in the connected respond number 6 registry to make necessary endorsement in the cost title. List this matter again after the vacation by reflecting the name of the learned SC Finance in the cost list.
Item 13.
Copy of the written instruction be retained in the record.
Wait, Mr. Lordship, this is regarding ex gratia, my lord. The husband of the petitioner, my lord, killed by unknown miscreants, my lord. Accordingly, my lord, the FIR lost by on Jagadish.
Yes, you have received instruction.
Lordship, the NOK is not annexed in this case.
Sorry,
Next of kin certificate is not annexed in this case, Your Worship.
what is,
That is
why is this,
required.
all this matters, NOK,
My
NOK?
lord,
It's
in,
They are
required.
knocking you out on that.
my lord, in this regard, I have submitted, filed an additional affidavit, my lord. NOK is not required, my lord. Page 35 of
Why NOK is not required?
because here, my lord, power is delegated, my lord, only on the basis of report submitted by the DC and SP are required, my lord, as per their notification, my lord. This is the
What do
notification.
you have to say on this, Ms. Bordele? You have not filed any
Lordship,
rejoinder.
Lordship may kindly peruse page 13, Your Lordship.
Page 13.
Yes, Your Lordship. There, Your Lordship, in each and every clauses, it is written ex gratia grant to the NOK of the person. So NOK word is mentioned. If the NOK certificate is not given, Your Lordship, then the payment issue becomes a little confusing because tomorrow some other person may come and claim that they are the real NOK.
And why do you say NOK is not required?
NOK
Because,
is
my lord,
there in
kindly-
every clause, Your Lordship.
Page 35,
Yes.
in my additional affidavit, my lord.
Hmm.
In the right column, my lord, general condition. In the top serial number 1, my lord,
Hmm.
provided that budget provision is available, then B, on the basis of report submitted by the DC/SP of the district. This is the required documents, my lord. But
So who has died in this case?
my lord, husband,
Died in what?
In a road accident, Your
no,
Lordship.
my lord. Killed by unknown miscreant, my lord. Page 16, the FIR. Then, my lord, FIR submitted, my lord. After investigation, FIR submitted page 20,
But why don't you give a NOK? What is the problem?
my lord. There
Tomorrow
is no
some other
problem, my
lady
lord,
comes.
but
Then we'll
Not-
hear it in due course. This is a legal issue.
and my lord, one more thing, my lord. Kindly come to page 13, the notification, my lord. Only the NOK is mentioned, but whether NOK certificate is required or not, that is not mentioned, my lord. And no other things is mentioned, my lord. Only the NOK, and I am the NOK, my lord. I have given the statement, and I have also annexed, my lord, the voter ID, where, my lord, my husband's name is shown, my lord, against my name.
All right, we'll hear it in due course
Yes.
then. These are legal issues. Today we can't hear it.
My lord.
But you are delaying the matter. Heard Mr. Soil and Counsel for the petitioner.
And in this
Also
regard,
had
my
Mr.
lord,
N.
in the
Bottomley.
earlier occasion, directed the respondent also, my lord, to produce the documents, my lord. Kindly peruse the earlier order, my lord.
And Bordele Learned Council is hearing for the Revenue Department Assam who submits that due to non-submission of next of kin certificate bracket NOK, the process for disbursement of ex gratia relief to the petitioner could not be concluded till today. From a perusal of the standing government notification, it appears that an NOK certificate will be essential for processing the claim of the petitioner. In view of the above, the petitioner to obtain and submit next of kin certificate before the concerned authorities within 4 weeks from today for enabling this court to pass appropriate order disposing the writ petition. Let this petition be listed again after 4 weeks as a fixed item. You get the NOK and submit it. We are not getting into all these legal issues for this. These are all.
Sure.
Why are you unnecessarily creating? You will say something and we will go into the books and law and find judgments and write it after 6 months. We don't have time for all these things. Give NOK, we'll ask them to process your claim.
Actually, my lord, this is the notification
All right, all
by
right.
the government, my lord. I have annexed in the additional evidence.
Any decided case there NOK is not required?
No.
Then we'll hear it. No,
Tomorrow
he's
some other
unnecessarily
person will
creating
come,
some-
your lordship.
Sorry, that's
Obliged.
the order.
May I please, your lordship, due to illness, my senior has not come today. Matter may possible for the dealer.
The petitioner's counsel seek adjournment in this matter with a request to post this matter again after the visa vacation on the ground that a senior could not come to the court today. The prayer is not opposed by learned counsel for the respondent. In view of the above, this matter be posted again after the visa vacation. Who is appearing for whom?
Lordship, I'm appearing for respondent number 6 finance.
Who is for one?
One.
You give your appearance slip.
Union.
You give an appearance slip. Last 18 years.
May I please also, this petition has been filed to extend the benefit of Indira Awas Yojana house lordship. The petitioner's name has been shortlisted in the first priority list, but in the second priority list, his name has been off-listed, and he belongs to BPL category lordship. The respondent number 4, that is block development officer, has already filed affidavit in opposition, and we have received. But we need lordship 2 weeks time to file affidavit in regular lordship.
All right. Take Mr.
BC Dhaka lordship.
Rishi Dekal and counsel for the petitioner prays for him granted 2 weeks time to file rejoinder to obtain instruction and file rejoinder in response to the counter affidavit filed by the respondent number 4. Ms. N. Bora, learned SC PNRD Assam and Ms. S. Sharma, learned G Assam are present on the official respondent. Let the matter be listed.
I will file additional affidavit. My NOK is required. NOK certificate is required.
Mr. H. Ahmed, HR Ahmed, learned counsel for the petitioner prays for 4 weeks time to file affidavit. Bring him on record the NOK certificate of the petitioner. Ms. N. Bordeloi, learned standing counsel, Revenue Department Assam, and Ms. S. Sharma, learned G Assam are present on behalf of the official.
Next case, similar matter.
Let the matter be listed after vacation. Same order in the next case.
Obliged.
Obliged, your lordship.
Next, my lord, here, my lord, fair price shop, my lord, was holding by the petitioner, my lord. And her fair price shop was, my lord, holding, my lord, according to them, my lord, less than 50, my lord, customer. But as per my lord, record, my lord, she was receiving, my lord, 54, lordship, kindly have a look. Page 22, annexure 3, my lord. She had, my lord, received, my lord, ration of 54, my lord, cards, my lord, serial number 18, my lord. May 2022 up to May.
You don't want to file rejoinder.
My lord, I am admitting, my lord, and they are also some extent admitted, my lord. Here was.
You have got the copy of affidavit in opposition filed by.
Yes, my
respondent.
lord. My lord, they have stated fact, my lord. Fact, what happened, my lord. They
You don't
according-
want to file any rejoinder. There are allegations against you. If you don't file rejoinder, I'll accept it and dismiss the writ petition.
My lord, then I will.
All right, heard Mr. Burville Learning Council with the petitioner who prays for and is granted 2 weeks time to obtain instruction and file rejoinder in response to the counter affidavit filed by the respondent number 3. There are allegations against your
Yes,
client. Mr. Sharma Lana G. Assam is present on behalf of the official list.
Obliged. After vacation, Lordship.
Not appears for the petitioner on call. Mr.
1 and 2, A Dhanuka, Lordship.
A. Dhanuka Learned Council is present on behalf of respondent number 1 and 2. Since the petitioner's counsel is absent today, that this matter will be listed again after the puja vacation. Is there any interim order here?
No.
So Mr. Barbara will finish the list and then take your matter. Just 2-3 more cases. Yes, where is the petitioner counsel? What is this case? None appears for the writ petitioner on call. Mr. B.J. Talukdar, Learned Senior Counsel, listed by Mr. P.K. Mehdi, Learned Counsel is present on behalf of the state. Since the petitioner's counsel is absent today, this matter cannot be taken up for admission hearings as such. Let this matter be listed for admission again after the reopening of puja vacation.
Item 23.
My please, your lordship. Here, my lord, the affidavit has been filed by the respondent, my lord. Kindly peruse last order. In terms of the last order, my lord, the petitioner appeared before the respondent, circle officer.
So what is to be done today?
My senior friend may obtain instruction of what has been done there after. After appearance of the petitioner before the.
Had Mr. Amar Kondakar and counsel for the petitioner peruse the order dated 19/6/2023 passed by this court. Mr. Talukdar, Learned Senior Counsel appearing for the state of Assam, prays for and is granted 4 weeks time to seek instruction as to the developments that might have taken place pursuant to the order dated 19/6/2023 passed by this court. Let the matter be listed accordingly.
I'm.
Item 24.
May I please, Lordship, this matter relating to non-payment of victim compensations, Lordship. Affidavit has been filed, Lordship, by the DLSA, Lordship.
I'm not the realist, I'm from SLA.
Lordship, that report has been enclosed by the State Legal Service Authority, Lordship. That affidavit has been filed, Lordship.
Yes.
Page 41 of my affidavit, your lordships. Lordships, if I may just place the few facts before your lordships. What has happened in this matter was that the petitioner's husband was killed by mob lynching. Now thereafter, she had given an application and a case was also registered under the by the DLSA, which was victim compensation case of two of something. I have the details here, your lordships. Thereafter, after an inquiry was conducted, an interim compensation was duly granted to both the petitioner and her daughter. 50,000 rupees of interim compensation, which is what the victim compensation scheme demands. Thereafter, now he is asking for the rest of the entire payment of 8 lakh rupees, which naturally, your lordships, will now be subject to the outcome of the trial. So the trial is still under process. I'm not sure why this writ petition has been filed, because in the interim, a compensation has already been granted to her. Her husband was killed. And that is not in dispute.
What we'll do is.
Lordships.
There is another matter, which is that item, that victim compensation case.
Item 12 today, your lordships, we had missed it because our names were not reflected in the
All right.
cause list, your lordships.
What we'll do is we'll have this along with item 12. There is some finance issues also. We'll
Lordships, yes, finances, because although a sum of rupees 9 crores has been sanctioned towards Asalsa, but the FOC has not yet been issued to us. And so therefore we are in a slightly
That's why
problematic
we'll
situation.
look into all these aspects because
Lotships.
there is no money at the moment.
There's no money at
Question
the
of-
lordships.
Yes, heard Mr. I Rafiq Learned Counsel, I Hawk Learned Counsel for the petitioner. Also heard Ms. R.S. Chaudhary Learned Standing Counsel Asalsa appearing for the respondents who submits that interim compensation of rupees 50,000
Each
has already been paid to the petitioner and her daughter,
lordships.
but the balance amount cannot be paid until and unless the
The
trial
Trial
is
com-
concluded.
lordships.
Full stop. It is also the submission of Ms. Chaudhary that at the moment funds are also not available and therefore the Asalsa is not in a position to make any further payment.
Correct.
Having heard the submission of learned counsel for the parties, this matter is directed to be listed again along with item 12, which is fixed on, what is the date fixed in item 12? Just check from Govinda. On that day, we'll see.
Lordships.
Highly appreciated.
Yes, who is appearing? Item 25. None appears, is it? None appears for the parties on call. List again after the reopening of puja vacation.
Item 26 will be called up as a last item. Item 27.
Yes, after 27, you call 26, yes.
Lordship, in this case, I am,
FCI will be listed.
Lordship, in this case,
Relates to Tinsukia Municipal Board, my lord, that
I am appearing as a capital for private respondent. Lordship. The copy may be served, Lordship.
tomorrow.
All right. Tomorrow, copy will
Copy will serve
serve.
tomorrow. In a fix the matter after vacation, immediately we will file the affidavit.
On
Agree on a date,
On 7, Lordship.
Yes.
7.
Lordship, on 7, I will on 9.
On 9. Mr.
Please agree on a date at least.
6, Lordship.
Your opinion.
Heard Mr.
Then
Bishop,
8
learned
Lordship.
counsel for the lead petitioner. Also heard Mr. S.S. Roy, learned counsel appearing for the respond numbers 2. Respond number, who is for 1?
One is for
The government is there.
Also heard Mr. P.K. Mehdi, learned counsel for the learned G. Assam for appearing for the respond number 1 and Mr. S.S. Roy, learned counsel representing the respond number 2. Mr. S. Deka, learned counsel is appeared in this case on behalf of the newly implemented respond numbers 3 and 4 and prays for 2 weeks time to obtain instruction and file affidavit. Prayer is allowed on the request of learned counsel for the private respondents.
That of 14.
This matter is directed to be listed again on
14. 14. 14.
14th of November 2023 as a fixed item. The respondents may bring their stand on record by filing counter affidavit on or before 9th of November 2023 by serving an extra copy upon the petitioner's count.
Okay.
Item 26.
Yes, who is appearing?
My lord, in this matter, Mr. B. Pathak was supposed to appear from BC.
Yes. You can appear. We have permitted that.
Hello.
You can appear. Yes.
My lord,
Yes.
my lord, this matter pertains to land acquisition. The deputy commissioner's office, my lord, for establishment of their own office, my lord, had taken possession of my land in June 2022, my lord. But then no acquisition compensation was processed. Upon filing of this writ petition, my lord, now they have filed an affidavit stating that the matter is under process for payment of compensation, my lord. The only issue now is that 16 months have gone by, my lord, and how long it would take, my lord, is the only issue as of now.
Which paragraph in the affidavit?
My lord would look at annexer 8 and 9 of the affidavit of the deputy commissioner. They have shown the proposal there, my lord. Page 65, 66, 67, and 68, my lord.
Paragraph 12, Lordship, we have stated. Paragraph 12 of my DB.
Yes, how long will it take to disburse
My
the
lord,
amount?
we have stated here that after receipt of the estimated amount from the requiring department, then that will be disbursed.
Which is the requiring department?
This is general administration. GD.
Why this
It-
land was acquired?
Acquired for the purpose of setting up the deputy commissioner's office over
At?
there. At,
Rupnagar, my
I think Rupnagar.
So who is appearing for the GAD? GAD is a party here.
GAD is a part.
No, no, my lord, GAD is not the party, my lord.
Then is it not necessary to make the GAD a party?
My lord, since now, since the issue of fund sanction is with the GAD,
Hmm.
my lord, otherwise the proposal was to be, because deputy commissioner is otherwise the authority to process land acquisition, my
That's
lord.
right, deputy commissioner will pay, but the requiring department has to release the fund.
My lord, if they do not, my lord, we have to add them as a party, my.
And the assessment of GRAT was done by the PWD department.
So Mr. Pathak, why don't you add GAD and PWD?
My lord, PWD at this stage is not required because if there is a dispute, my lord, there will be a reference case. But then GAD, my lord, we have to add, my lord, since the funds are not coming from their side. My lord, let it come after vacation, my lord. In
All
the
right,
mean-
and Mr. B. Pathak, learned counsel who has addressed this court through remote video conferencing, bracket RBC. Also heard Mr. B.J. Talukdar, learned senior counsel assisted by Mr. P.K. Mehdi, learned counsel representing the respondent numbers 2 and 3. Ms. G. Hazarika, learned SC Revenue is present on behalf of the respondent number 1. The petitioner is aggrieved due to non-payment of land acquisition compensation despite the lapse of more than 16 months since the land has been, possession of the land has been taken over. Full stop. From the affidavit filed by the respondent numbers 2 and 3, it appears that the claim for compensation is under process and the amount would be released as soon as the fund is received from the requiring department, which is the General Administration Department of the Government of Assam. However, the GAD, General Administration Department, bracket GAD. However, the GAD has not been made a party in this writ petition. Situated thus, on the request of Mr. Pathak, liberty is granted to the writ petitioner to implead the GAD as a respondent in this writ petition by filing appropriate application. Let this matter be listed immediately after the application for impleadment is brought on record. File it? Yes. All other matters are over?
I'm obliged to your lordship for accommodating me for the time being, madam.
No problem.
Your lordship has on last occasion sought for the materials which was placed before the accounts.
Acha, just a minute, we'll go into those things. First, let me understand a few basic things. Last time, the arguments and the pleadings were placed. So the job of handling at the railway siding was given to another contractor.
Was given
Not
to
the
another-
petitioner.
Yes, madam.
Petitioner was only to lift the items from the
Railway siding
not
and
from the railways, but from the handling contractor.
yes, madam.
And then carry it to the FSD Badarpur
Badarpur.
and unload it and stack it there.
Yes, madam.
That's the job,
Yes, madam.
right?
Yes.
Now, which is the contract, which is the clause which is being sought to be enforced here by the
FCA.
FCA? Which is that clause? Where
My
is
lord,
it?
that is, my lord, clause 10A at page 74. of the affidavit in opposition, running page is 121, my lord.
121. All right, what
Page
does it say?
74, down below, my lord.
Hmm.
Roman 10, liability of the contractor for losses, etc. suffered by the corporation.
Hmm.
The contractor shall be liable for the cost, damages, warfage, forfeiture of wagon, registration of fees, charges, and expenses suffered or incurred by the corporation due to contractor's negligence and unworkmanlike performance of any services under this contract. So, my lord, this contract was for
All right, so this is the contract, this is the term of the contract under which you are seeking to recover
damages.
damages. Now, there is some model contract, it seems I have found in the writ petition. There is a paragraph where, I think paragraph 22. They have mentioned about some model.
That is model tender form, my lord. That is the agreement. If your lordship will again come to, it starts from page 61 in my affidavit of opposition, which I have annexed, my lord.
No, I am saying demurrage is surplus 21 of clause 20 or
Now, clause 10E, my lord.
not clause 21, not 21 of clause 20.
Clause 21 of clause 20 liable to make good any corporation, that is at page 63, my lord.
Page 63.
63 of my affidavit in opposition, running page is 132.
You go.
Here the
Running page 63.
running page 86, my lord.
Yes. What does?
Clause 21, my lord. The contractor shall be responsible for unloading, loading of wagons within the free period allowed by the railways, and also for loading, unloading of trucks, carts, and any other transport vehicles.
Just a minute, I'm not, you are referring to your counter affidavit.
Yes, my lord.
And which is the serial running, the page of the counter affidavit, which page?
86, my lord.
And the running page will be?
132, my lord. Page 86 may be followed, my lord.
Yes. Yes, I have seen. What is this? What is this?
This is applicable to the handling contract, my lord.
It is applicable to the handling
contract,
but not the side, not the.
not to
transport
the
contract.
present contractor. It's a model tender form. It's a standard,
So this clause is not applicable to the petition.
not applicable. Clause 10E will come into play, my lord.
Yes. Right.
In my case, in this case, my lord, 10E will be applicable, where he has to provide the trucks when the indent is given to the contractor. He has to place the indented trucks, required number of trucks at the time of unloading. Labors are always available. Their labor's contractor was the Anup Trade. So, my lord, can I place this, my?
Yes.
My lord, this is the warning notices, first of all. 16/12/21, asking them to provide the trucks, my lord, at the railway siding.
Yes.
These are all warning notice. Then next page is 3/3/2022. Then third is 15/3/2022, where the second para, may I read it only one line? Till at this hour, that is 2013 hours of 15/3/2022, 4 wagons assigned for FSD Badarpur Ghat are still pending for unloading. The matter also been apprised to you through telephone. However, no further communication received from your end, nor the representative of High Speed Logistics Limited is available at this site. This clearly shows major lapses from your end. Then next page is 16/6/2022. Again, warning letter, my lord. So, my lord, now that flag mark 1, my lord, how the damages charges are calculated, my lord. That is, we have given the example of for the month of December 2021, my lord. The order is dated 14/2/2022, my lord. The damages liability is fixed as per clause 10A of the MTF, which I have read just now, 10A, my lord. So here, my lord, there were 5 contractors, RTC, road transport contractors. So, yeah, proportionately, the damages has been imposed because of their failure to provide the trucks at this railway siding. Now, the column 6 says that handling contract. Handling, there was always the labor, so there was no damage incurred because of the lapses on the part of the labor. That is for unloading from the wagon, my lord. My lord, may kindly be seen.
No, I'll see, but Mr. Singh, the problem is we are on a very, very different legal issue.
My lord, 2 issues that
I am accepting that he has failed to place the trucks on every occasion. Listen to me. Even then you cannot recover damage unless there is a decree from the civil code. That's the law. You have to argue on that. We are not at all concerned whether he is actually defaulted or he has not defaulted. The question is, even if he has defaulted, you cannot unilaterally deduct. The reason are threefold. Please listen to this. And I would request you to address the court on that. FCI is one end of the contract. Because you are a corporation, you don't enjoy any special status under the Contract Act. A contract is a contract. It is same as the contract between 2 private individuals or contract between a contractor and a corporation. The contract does not change its character because it is a corporation or a government entity. It is the same. So we will go by the law of contract, not by whether it is FCI and therefore some leniency should be shown. Those things are, please, Mr. Singh, please listen.
Yes, I'm listening.
Otherwise, you will miss the
No,
bus. You will not even realize which way the judgment is going. So your emphasis on showing that the contractor has failed to place the trucks in place is going to be of no moment, right? We are not even going to record a finding whether he has been defaulter or not. The question is, as per you, he is a defaulter, but he has not admitted it. He has denied it. So when one party in the contract makes an allegation and the other party denies it, there are 2 ways of compensation. One is under section 73, one is under 74. 74 is called liquidated damage. When the consequences and the amount of compensation is spelled out in the contract. Correct. If that is there, then it will be automatic levy. And the other party has to go to the court to have the declaration that it is illegal. But if it is not a LD clause, liquidated damages clause, then subject to what you may say and what Mr. Borbara may say, he has not argued on that line yet. Then it comes within 73. There is a whiff of 73 in the Supreme Court judgment also. Then it is a question of breach of contract by either side. Now, in case of 73, it has to be in the civil court or in the form of an arbitration. If the corporation didn't realize it, we can't help it. In case of LD, there could be an element of unilateral deduction because the contractor has agreed that if these conditions are met, he or she will be liable to penalty. Whether that has been wrongly invoked or not is a matter which can be challenged in the court. These are the 2 broad areas which you must be very clear. You cannot invoke this clause against the contractor for 2 reasons. First of all, the Supreme Court has effectively held in clear terms that unless the contractor is entrusted with the handling work in that Abhijit Pal case, you cannot impose damage on him under that clause, even if charge can be included to include damage. That is a clear finding of the Supreme Court. I have read the judgment. So in this case, since the contractor was not in charge of handling at the railway siding, because of the Supreme Court judgment, even if he is a defaulter, you cannot even levy it even by going to the in the civil court. Even by going to the civil court, you cannot do it because of the findings of the Honorable Supreme Court. That's what I understand. But leave that aside for a time being. Because it is not a LD clause, you cannot unilaterally do it even if he is at fault. There has to be an adjudication of the dispute by a process established by law, which can either be an arbitration or it can be a civil court proceeding. You are one of the parties to the contract. You cannot decide that he is. If that was the intention, then you had to put an LD clause there, which you have not done. LD clause is not there. If the clause was that such and such amount will be deducted for default as a liquidated damage, the matter would have been different. It's not a liquidated damage clause. And secondly, how do you overcome the Supreme Court decision which says unless the contractor is asked to do the unloading at the siding, you cannot impose damage on the contractor. So you have to address the court on these two issues. If you can satisfy, we'll dismiss the writ petition. If you cannot, we'll allow the writ petition. You have 5 minutes to organize your thoughts as I come back.
Yes.
Yes. And Mr. Borbora, please address the court on the LD, liquidated applicability of liquidated damage. Section.
Contract has been referred to, that is for their.
No, on the law point, what would be the effect of, is it a LD clause or is it a non-LD clause? What would be the effect of that?
Supreme Court case, my lord, made a reference to my lord, the Indian contract that charge, whether it is charged or not.
That is not going to be of any help to you. That was a case where demurrage word was not included. So Supreme Court interpreted whether charge will include demurrage or not. That they have relied on an earlier decision to say that it will. But the Supreme Court says even if it includes, even then because the contractor is not the handling contractor, he will have no liability of demurrages. That is the only thing which saves you. Otherwise, tight case. And that will.
The liquidated damages covers under the clause 10B, my lord, and plus contractor is bound by this agreement. There is another clause 18, law governing the contract and disputes resolution, my lord. First of all, I will take your lordship to page 75.
Page 75 of
the affidavit in opposition. Internal 75 running 120.
Yes.
May I read it, my lord? B. The corporation shall be at liberty to reimburse themselves of any damages, losses, charges, costs, or expenses suffered or incurred by it due to the contractor's negligence and unworkmanlike performance of the services under the contract or breach of any terms thereof. The total sum claimed shall be deducted from any sum then due or which at any time hereafter may become due to the contractor under this or any other contract with the corporation. In the event of the sum which may be due from the corporation as aforesaid being insufficient, the balance of the total sum claimed and recoverable from the contractors as aforesaid shall be deducted from the security deposit furnished by the contractor. Should this sum also be not sufficient to cover the full amount claimed by the corporation, the contractor shall pay to the corporation on demand the remaining balance of the aforesaid sum claimed.
This doesn't happen. This kind of clause you cannot.
Then this clause, my lord, 18, page 78, my lord. Laws governing the contract and dispute resolution. The contractor will be governed by the laws of India for the time being in force. B, in case of any dispute arising out and to bring upon the this in case of any dispute arising out of the out and to touching upon the contract, the same will be the first referred to dispute grievance redressal committee constituted and functioning at the general office of the corporation with a view to settle the disputes. The role of GRC shall cover the period from the date of the award of the contract. If any disputes remain thereafter, the same will be settled in the court of law having competent jurisdiction. My lord, the petitioner has not invoked this clause.
You first distinguish the judgment of the Supreme Court that has sealed everything. If I write, I'll write a 7-page judgment here. This is entirely covered by the Supreme Court judgment. Abhijit Pal is the same thing. Is it not? Does it not arise out of Abhijit Pal in WPC number 367 of 2012?
Yes.
That is one of the decisions. So there, the
My lord,
same
at
thing.
paragraph 26 of the Honorable Supreme Court judgment, it only touches is that the contractor was not the handling contractor at that particular siding. Otherwise, it has not stated that because he was not handling contractor, damages charges will not be recovered from him. It has only distinguished between the charges and
No, Supreme Court, two issues were there. Whether because in that contract, demurrage word was not there.
Was not there.
So whether charges will include damages
or not.
That was the
core issue, my lord,
Core
before
was
the
the
Supreme Court. So
there the Supreme Court has relied on the earlier decision of Raichand Amulak Shah
yes, my lord.
and held that demurrage is undoubtedly a charge. Demurrage is undoubtedly a charge. However, such a contextual understanding would not help us decipher the true and correct intent of the parties to the contract. Then it says the decision of the High Court of Tripura and so is upheld. And in para 32, it says it is evident from the above that handling and transport contract from 2018 similarly involve loading and unloading of food grains from the railway wagons within the scope of contractor's duty, thereby necessitating the inclusion of demurrage as a penalty for non-performance of contractual duties. Thus, the present road transport contract is distinct from the handling and transport contract, as responsibility of loading and unloading of food grains from railway wagons is absent in the present contract, which is same as that.
That's why the damages word was not included, because that was a handling contract.
Correct. So even if it is included, it cannot be levied. That's the meaning, internal meaning of this. That is the ratio. It was not included because it cannot be invoked. So even if you include it, it cannot be invoked for the same reason. That's what I'm asking you. If you cannot clarify on that, where is the scope for this court to go very deep into the matter? I cannot, as a single judge of the High Court, reinterpret the decision of Supreme Court and add words to it. The Supreme Court appears to be very clear, and the concluding paragraph 34 says the High Court's decision is upheld. The High Court has said what? See the judgment of Justice Talapatra.
Yes, ma'am.
It has clearly said that if you want to levy it, you have to give him an opportunity of having his say, and through a process established by law, which means there has to be an independent dispute redressal mechanism. Whatever name you give it,
I'm getting your lesson.
you tell that, okay, we'll decide. If I say, if my manager says that's final, these are things you can put it in your contract, but these have got no value. The courts will never accept this. These are not in consonance with the public policy. Ultimately, it is either it has to be an arbitration, which is again an independent mechanism, or it has to be through a court decision. You cannot on your own say that, look here, you have done this, so you will be liable to pay this. That is what appears to be the decision of the Supreme Court, because the contractor is not a handling contractor. If it was a handling contractor, then maybe depending on facts, this was permissible. But if it is not a handling contractor, you cannot hold him liable for unloading happening beyond the free time. Therefore, if the unloading happens beyond the free time, it is not to be put in the heads of the contractor, transport contractor. That's the meaning of the judgment. If that is the meaning of the judgment, then how does it matter whether he placed his vehicle on time or not? At least the damage cannot be raised on him. That is the biggest obstacle FCI will be facing in this case because of the decision of the Supreme Court. This is binding on this court. How do we explain that? If you read the relevant paragraphs of the decision and the judgment in the case of Abhijit Paul by the single judge, this is exactly what has been held. Only difference is that, and in Abhijit Paul, demurrage is there. You look at the contract which has been quoted. The clause which has been
Abhijit
quoted.
Paul damages was.
Yes, even that was declined and the Supreme Court has upheld it. How do you expect the coordinate bench in another high court to take a different view in the matter?
The
Unless we
Abhijit Paul
address,
damages was there, but in the clause it was not there. In the clause it was not there, MTF. In the Abhijit Paul, damages was recovered, but it was set aside because the word
12A, page 3 of that Abhijit Paul judgment, see, it has been quoted. Mr. Singh,
Yes, ma'am.
has it not been quoted? Damage is there. Why do you say it was not there? Damage has been quoted and see para 8 of that judgment. However, it is well settled that read from there, middle of the paragraph.
I'll leave it to you, Lordship.
Why you leave it? You argue. Either you disagree or
No,
you.
It's coming on the way, this Honorable Supreme Court judgment.
Absolutely. The problem is there is probably
The FCI case may
there
not
is
be
a scope
closed
of
down, my lord.
dealing with it, but then this court cannot go into it.
My
Should
humble
have not-
submission is that, my lord, the FCI cases may not be closed, shut down. He may invoke and may take proper
No,
course.
certainly. That cannot be shut down.
That may be looked into, my.
FCI can always initiate appropriate legal action for recovery of damages, compensation. That he cannot, the writ court will not preempt that. That cannot be preempted. But the issue here is, can you on your own start deducting by holding the transport contractor liable to pay damages by holding him responsible for unloading happening beyond the free time? The answer has to be no in view of the judgment of Supreme Court, because the Supreme Court says it is the handling contractor which will be responsible for this. Maybe in a given case, the transporter has a role, but you cannot decide it. You cannot decide it. That is the point. That is a dispute that has to be resolved in a forum.
Competent.
That is the only point here, nothing else. Nobody is saying that the contractor has been absolutely clean. That nobody is saying. And you should, despite these judgments, you have not changed the wordings of your contract. These judgments.
My lord, it's over now they are coming up, my lord. In the northern part of the India, my lord, this clause is not there. Their damages has to be paid by the contractor itself. He will have to look into that. Now, this thing is also
Then
coming.
it makes a LD clause.
Yes,
If it
my
is
lord.
a LD clause, then it's a completely different.
FCI is not facing this thing in the northern or other part of the India. Only in the northeast they have not included. Now they will do so.
That is up to them.
Otherwise, it will be very difficult for the FCI to work, my lord. They will come at their whims.
No, you are right. But then you have the right contract clauses then. You cannot have some clause and implement it in another way. The problem is the FCI thinks because it is the food corporation, law will treat it differently. That doesn't happen. It is just a party to a contract agreement. That's all. Law of contract will go by what is the law, not on the basis of who is the party. You can't do that. That's what Supreme Court on this particular issue on the same clauses have interpreted. Where is the scope for this court to take a different view? It'll amount to. It'll be a judgment per incurium if a single judge takes a different view in this. matter.
Yes, ma'am.
Cannot be done. Subject to that, you are free to argue whatever else you want to. Have you understood the point?
Yes, ma'am.
That's important. Yes, Mr. Pavra. You have nothing to add.
The whole thing, my lord, 3, 4. One is, my lord, the jurisdiction, general manager is the authority and not this district level officers.
No,
As-
that
That delegation of
That was
powers
also,
there,
that was,
that para that is there in.
in
no,
the,
it's all right. That was one thing. Then suppose this district manager has the authority, he has to follow some procedure. He cannot unilaterally. And give a notice to me, giving me opportunity to confront.
That is right. That's the only point here. That's the only point.
Just go, cannot go on
They can raise
unilaterally.
a
deny.
demand and if they fail to, if you fail to. play-
Entire
to
demand.
answer,
my lord,
to answer
body-
my learned senior friend, my lord, the petitioner may approach the author to the FCI and then work it out why it is this much of damages charges.
We can't comment on that.
He
So
can
that's
come
all.
here just.
Legal issue.
And this Talapatra judgment, earlier Justice Biswas's judgment, my lord, honorable justice, and then the Supreme Court. That's all.
All right. We'll go through the record and see. I don't know whether it will be possible to deliver judgment before vacation. So it may go after vacation. Contract is valid till 20th of November.
Yes, my lord.
Yes, madam.
28th of November.
So we'll try to deliver the judgment before that, immediately on reopening.
My prayer is, my lord, simple, my lord, to refund the amount so far deducted, that has been deducted in spite of an interim, forget about interim now. And my lord, within a time limit. Because by today, they have deducted, my lord, nearly 2 crores. How can a, my lord, contractor survive? And I am
That's
not,
right. If he succeeds, then you have to refund him. And then it will be up to the
That-
FCI to take whatever legal remedy is permissible under the law.
let them go for a civil suit.
What you are doing is not permissible. Change your contract clause. For future, you change it.
And there your lordship is absolutely right. I think it is high time for them. In so many cases, these model tender clauses, they need certain upliftment. Otherwise, they will be continuously in problem.
No, they don't change it for a reason which we know. They will themselves be in trouble if they change it. If they put more teeth to it, then the corresponding obligation will be such that they know the reality. They know the reality in what circumstances, what ambience these things operate.
And my appointment is after 2018. 2000